Let us continue that. As Indian students, for example, it may be ease of getting visa, ability to travel during time of COVID, perhaps even employment after studies. If you are business person, it could help with access to foreign market, receiving information about the regulation and practices while circumstance demand. But you do not have to be abroad to need foreign policy. It matters at home just as much. When it comes to security, or external or internal diplomacy could be preventive mitigator or problem solver. The big issue of our time is pandemic, terrorism, climate change impact your very existence. And ask yourself whether we should not have a greater say in search of solution. The world being what is self-interest. Increasingly, the foreign policy facilitates the creation of new capacities at home. It may be informal technology, information technology or auto manufacturing, food production or food processing, metros or bullet trains, space capabilities or nuclear energy. Fruits of foreign collaboration are there today for all us to see. Okay. One, we must bring about change of thinking in the world about us. Two, partners we should create should be on more equal terms, with small countries more generous. Three, global agenda, big issues of our time should be shaped by India as much as possible. Five, the very conceptualization of foreign policy should be more people centric. Six, our culture, tradition, thoughts should percolate our own articulation as well as influence international debates and initiatives. Yoga, Ayurveda were obvious examples in this record. Next article is a reformer on the bench. Okay, Ramesh Chandra Lohati, who breathed his last on Wednesday. He had joined the Apex Court bench in 1998 at the beginning of three new millennium, pronounced judgment on two controversial issues in Muslim law, divorce and bigamy. There has been an abominable practice in India under which, when deserted a Muslim wife, after long years of waiting for reconciliation, approaches a court to seek financial relief. The unscrupulous husband tries to defeat her rightful claims by pretending to have quietly divorced her sometime in the past. In many old cases during colonial rule, the court had accepted such a plea and denied relief to aggrieved wife. These precedents were followed by some high courts also after independence. Lahoti confidently held that under Muslim law there is proper procedure for talaq, and that unless the husband proves meticulously compliance with the prescribed procedure, his claim of having divorced the wife cannot be accepted. He said and declared that in case of before him, neither had the marriage been dissolved nor had the husband's financial liability towards his lawfully wedded wife come to an end. Okay, Lahoti threw into the dustbin of history the practice of Muslim husbands using divorce plea as an afterthought in their wives' legal cases, desperately seeking relief, honoring by citing my scathing critic. Okay, an unconditional permission for polygamy is erroneously believed by sections of common Muslims to be part of their religion and personal law. Under this mistaken impression, they think having children from each of the multiple wives should also deemed as religious privilege. Any general law of the country, which even in the remotest way curtails their alleged freedoms in the matters, is seen by the country as to their personal law of professedly divine origin, and they seek exemption from it. Haryana State Law of 1994 has laid down that Gram Panchayat members having more than 2 children will be ineligible to seek election to Jilla Parishad. The restriction has meant to promote the smaller families and Planned Parenthood. Muslim contested pleaded that having multiple children was a natural corollary to the freedom of polygamy under the Muslims' personal law, challenging the state under the religious freedom clause of the constitution. He sought the exclusion from 2 children norm. Deciding his appeal, Lahoti rejected the foolish plea, that is Javed versus Haryana State 2003. No religious scripture or authority has been brought to our notice which provides a marrying less than 4 wives or abstaining from procuring children from each and every wife in case of permitting bigamy or polygamy would be irreligious or offensive to dictates of the religion. He declared and upheld the constitutional validity of Haryana law. The learned judge was absolutely right. The Quran had not enjoined or even encouraged polygamy. It had just allowed it. It's with a better not caution to be restored to be in special circumstance, subject to rather insurmountable restrictions. And certainly there is no religious injunction under Muslim law making it mandatory for polygamists to have children from all wives. Okay, this is what the article talks about. Next article is that we are moving into is related to finance bill. Crypto losses can't be set off against gains. Okay. Key amendment to finance bill include clarification on taxation aspects of cryptocurrency or virtual digital asset and deduction from surcharge and cess. Loss from transfer of virtual digital asset will not be allowed to set off against the income arising from the transfer of another VDA in the proposed amendment. Okay, government will define virtual digital asset with a view of 30 percentage of income from all transfer of such asset. Also, with the amendment, deduction of surcharge and cess which has been claimed and allowed to the taxpayers will be deemed under reported income and will attract 50% penalty. Making a retrospective amendment to Income Tax Act from 2005 says Finance Bill 2022 has proposed a retrospective disallowance of the deduction from surcharge or cess under Section 40, citing some court rulings that had given benefit to taxpayers in claiming cess as expenditure and not tax. That deduction of surcharge or cess has been claimed and allowing the taxpayers will deemed to be under reported income and the subject to 50% penalty. Okay, this is what the article is all about. Next one is new referral service Google under CCI lens. What is that? INS has said Alphabet Inc., which is a parent company of Google, Google LLC, Google India Private Limited, Google Ireland Limited, Google Asia Pacific were abusing their dominance in news referral services in the online news media market. Several countries, including Australia, France, Spain, have passed legislation requiring the tech companies, including Google, to adequately compensate content producers for using their content and search results. Okay, INS added, media houses are being kept in the dark on total advertising revenue collected by Google. What actual percentage of the advertising revenue is being transferred to media organization? Okay, and this is what the article is all about. If you like the video, please do share, subscribe, comment and like. Thank you.